Okay, good afternoon once again, and welcome to continuation of our discussion of terms of contracts. I told you that we were going to continue from where I asked you to the recording that I sent, so that we don't waste time. And that is exactly what I propose to do this afternoon. Unless someone has a question on what you listen to, otherwise we will continue with today's topic, which is implied terms. So maybe let me wait for, okay, just a quick recapitulation of what we have been doing so far under terms of contracts. We've explained what we mean by terms of contracts, and we've also made the point that it is necessary to properly classify the various statements which are made at the pre-contractual stage, that is the negotiation stage. And we have noted that some of the statements made before the contract is actually concluded may just be a representation, in which case it's just meant to induce the other party to make up his mind one way or the other to enter into the contract. If it turns out to be untrue, it can only give rise to an action in misrepresentation and not a breach of contract, because it's not part of the terms of the contract. We've seen that. And again, we've also seen that where the statement was meant to form part of the contract, then that is a term. Should it turn out to be untrue, or should it not be carried out, that will give rise to breach of contract. So we came to the next question, that how do the courts go about trying to classify these statements? We said that 4 rules of thumb, or 4 guides are there. The timing of the making of the statement, importance of the statement. Then we also look at the fact as whether the statement made orally the contract was subsequently written. So that if it was subsequently written and something which was just said by word of mouth did not find its way into the written one, then the assumption is that it was not meant to form part of the contract. And I think the 4th or the other requirement is that the court will look at the expertise or the special knowledge or skill of the maker of the statement. So that if the maker of the statement is supposed to be an expert or something like that, then that is what would actually guide the court in making the determination as whether the statement is a term or representation. Now, we would like to continue with our discussion of terms by looking at implied terms. Implied terms. So, as the term itself suggests, implied terms, we are talking about those terms which the parties to the contract have not necessarily negotiated. The parties to the contract have not necessarily negotiated, or they have not necessarily applied their minds to. And yet, for some other reason, the court is saying that it will form part of the terms of the contract. That is why I said that they are implied as opposed to express. Express terms, that is where the parties themselves have actually negotiated, or they have put their mind to it and say that we want this to also form part of the terms of the contract, as it were. Yeah, so on what basis will terms which the parties have not actually negotiated be considered as forming part of the contract? In other words, how do we get implied terms? So that is what we are going to be discussing. If we look at the literature, we have, if you like, three main ways in which terms may be implied. Terms may be implied by statute, that is, Act of Parliament or any enactment. Terms may be implied by custom. Terms may also be implied by the court. So let's look at this one after the other. Terms implied by statute. You may have a legislation which says that for certain types of contracts, certain terms should be considered as forming parts, even where the parties did not actually include them in the contract. Or you may have a legislation which says that for certain types of contract, some matters should be provided for. So we are making this provision in the event that the parties do not include them, then what we have provided in the law would automatically be considered as forming part of the contract. So some of the implied terms are default rules. Default rules in the sense that the parties to the contract who decide to disable them, who decide to make their own arrangements so that they are not binding. A lot of examples. If you look at the Sale of Goods Act, for example, the Sale of Goods Act, later on when we learn commercial law in the third year, it is a legislation which governs the relationship between the buyer and seller of movable goods. We say movable good, that is any good or item which is not immovable, which is not like the land type. So the legislation which governs those types of contracts, what we call the Sale of Goods Act. Now, if you look at the Sale of Goods Act, there are a number of provisions in which certain terms are being stipulated as forming part of the contract between the buyer and the seller of a good or goods. A number of them. Some of them are mandatory. Some of them are permissive or default, meaning that the parties may decide to negotiate something different. So there are a lot of examples. For example, if you look at the Sale of Goods Act, we have implied term concerning the quality of the goods sold. That where there's a contract between a buyer and a seller of a good, there is implied term that the goods or the item being sold is, for example, fit or suitable for purpose for which such an item is actually made, and so on. So therefore, where the contract is even silent on that, where one party is in there, but we never really agreed upon the type of quality the item should be. The Sale of Goods Act has made provision for that. And there's a case, a very old case, Farah against the Robin Hood Flour Mills Limited. If you can read that case later, but there was a contract for sale or purchase of a flour, and an issue arose as to the quality, and a dispute was that, yes, no specific quality had been negotiated and so on, but the court was prepared to rely on the provision of the Sale of Goods Act and say that, yes, whether or not the contract is silent, the Sale of Goods Act makes provision for the quality of what is being sold under the contract for sale of goods. Then again, we also have another implied term regarding existence of specific goods. If you go to the Sale of Goods law, if you like, we have two main types of goods. We have what we call specific goods as opposed to unascertained goods. Or some people want to add a third category called the ascertained goods. And some of you, instead of listening to what I'm saying, you are paying attention to what Mimi is doing. And you see how important Mimi's spirit is. When Mimi was absent, you were not happy, you see? Okay. Okay, so let's move on. Mimi, you're welcome. Good. Yeah, so the number of provisions regarding sale of goods which qualify as implied terms. There are a lot of examples. All that I have mentioned are just some of the examples. So look at section 9, implied term as to existence of specific goods. I think I was going to explain specific goods, and Mimi came in. So when we say specific goods, a specific good under sale of goods law refers to an item or article which has been identified and agreed upon by the parties, either before or at the time the contract is being made. So that if we have contracted about, let's say, the phone I am holding, if you have seen it and you know that this is the item we are contracting about, then that is a specific goods, as opposed to unascertained goods. Let's say that if there are 1,000 bags of sugar in a warehouse, and I say that I'm buying 100 bags of sugar, yes, we have agreed on the quantity, but should we go to the warehouse? We have 1,000 bags of sugar sitting there. Which of those bags of sugar are referable to the contract between us? You need to go through process of ascertainment. You do something to let the 100 become set apart from the whole lot. Either you do earmarking, some selection, and so on, so that we know that this is the 100. So you need to go through process of ascertainment. Not until ascertainment is done, the goods are called unascertained goods. But when it comes to specific good, because you have seen it before the contract is made, the law says that the seller has an implied obligation to ensure that the item is actually present. And that is very important. Of course, not only the existence of goods when it comes to delivery of goods by the seller. There may be question as to the contract was silent on when the goods will be delivered or when payment will be made. Then the law makes a provision that in the contract for sale of goods, there's implied term that delivery of the goods by the seller shall be concurrent with payment for the goods by the buyer. So as delivery is made, then you're also supposed to make payment. Of course, unless the parties agree otherwise, but if they haven't specifically negotiated that, then this provision will serve as a default provision. So that is the kind of thing we are talking about. It's not only the Sale of Goods Act which gives example of terms implied by statutes. There are so many statutes which in one way or the other imply terms. So we would like to also mention the Conveyancing Act. We take like the Conveyancing Act of 1973, which has now been more or less been replaced substantially by the new Land Act. We have covenants, if you say covenant, obligation for the transferor and the transferee. In other words, if there's a contract for transfer of interest in land, the owner of the land, the landlord, called the transferor, and then the other person to whom the transfer is being, let's say the tenant or the lessee. Certain obligations are supposed to be observed by the landlord or the transferor. I give you just one example. For example, there is what they call the right to quiet enjoyment. That if someone has taken, maybe has rented a room or has taken a lease of your property. Now you, as the landlord or the landlady, the law imposes an obligation on you not to interfere with the tenant or the lessee or the transferee for the period that the tenancy or the sublease or whatever will be in force. Don't interfere with his or her in quiet enjoyment. In other words, you have to let her have full possession and enjoy the particular room or accommodation as it were. Now, if the contract is silent on, for example, this particular thing, there's a law which says that there's an implied covenant, an implied obligation as to quiet enjoyment. Yeah, so again, as I have told you, there are a number of legislation in which we have terms being implied in one way or the other. So all that you need to know is to understand that terms may be implied by law or statute. In other words, there may be law which says that for certain types of contract, certain matters should be included in the content of the contract. So then you get example of such laws. So you've mentioned two, but there are a number of them which you can have. I mentioned the case of the Farah against the Robin Hood Flour Mills Limited, which is illustration of the implied term as to quality. So let's talk about another way by which terms may be implied. That is terms implied by custom. Terms implied by custom. How may a custom bring about terms, or on what basis may terms be implied using custom? Well, when we talk about custom, we are talking about local, maybe trade usages or practices, either in a certain industry or in a certain community. Some practices may be so well established that all those that operate in that particular industry or that particular community are very much conversant with those usages or practice that no one will deny or no one will contest that. So that will become a custom. So in a situation like that, where there is a contract in such an industry or such a community, in respect of which there's a certain settled practices or custom, even if the contract is silent on that particular thing, reference can be made to that custom in order to read those terms which the parties have not expressly incorporated into the contract into it. So that is what we have to pay attention to. There's a very old case, the case of a Hatton against Warren. Hatton against Warren, because we are friends and we ask you to know things that you do. I'm happy to call Hatton Abraham Robson. Who is he? Who's Hatton Abraham Robson? Yes. What happened in Hatton against Warren? Yes, Hatton against Warren. Because it's part of what I asked you to read. I asked you to do some reading, and I know I asked you to read and summarize that too. Okay, so Hackman, Candice, Hackman, is it Candice, Condus? Is it Candice? Where's Hackman? Prince Wharton. Okay, so since you are not forthcoming, I'll tell you what happened in Hatton and Warren. In Hatton and Warren, there was a contract between a landlord and a tenant. in relation to farmland. And there was a local custom to the effect that a tenant was bound to farm according to certain course of husbandry. And when the tenancy is coming to an end, the farmer was entitled, that is the tenant, to a fair allowance for seed and labor on the arable land. So you have to farm in a particular way. Should we decide to end the relationship and probably leave the farm, there was a custom that you should be given some of the seed and some, if you like, a bit of payment is made for you for the labor that you have provided. Now, when a dispute arose and the matter came before the court of Exchequer, the court was prepared to say that, yes, so long as evidence was clear regarding existence of this particular custom, the lease which had been made between the parties was going to be interpreted in the light of the custom. The custom that once someone is farming according to certain approach of farming, certain husbandry practices, and should he decide to leave the farming and want to go his way, the custom was that, yes, you have to, the owner of the land will have to give some of the seed and also make a bit of allowance for the labor that he has expended on the farm and all that. Now, these matters were not expressly contained in the lease, but the evidence was taken, and the court became convinced that, yes, that was the practice or the usage in the community. And on that basis, the court construed the lease or the agreement between the owner of the land and the farmer in the light of that local custom. A number of examples can be given as far as local custom is concerned. Just like you come to our own place, there's something we call abunu and abusa when you're doing land law later on. Someone will have like a farm is given to you to farm, and the produce is supposed to be split into, let's say, 3. If it's abusa, you are giving one goes to the farmer, one is supposed to be used for improvement of the farm and so on. And of late, there's been this debate that it's not just about sharing of the produce, but it's also about splitting the farm and so on. All these are matters of custom. So the point being made is that for certain types of contracts, some additional terms or some additional obligations or rights for the parties may be read into it, that is, maybe implied into it on basis of existing custom. So let's keep that in mind. Okay, good. Now, a similar thing happened in our own backyard, the case of Party and Noga. Very interesting. It's about animal rearing or husbandry. So in Kwate and Noga decided in 1967, the plaintiff sued the defendant for 13 cows, which the plaintiff thought should have been his share of the products of 2 cows left with the plaintiff by the defendant for adjustment. And the plaintiff alleged that by an oral agreement between himself and the defendant in 1936, he undertook to adjust, feed, breed, and take care of 2 cows deposited with him by the defendant. The defendant just gave 2 cows. And according to the plaintiff, The terms of the agreement were further that the defendant will pay him amount of money, 5 shillings on each of the first 2 cows produced, and that he should be entitled to the 3rd cow and every subsequent 3rd cow as compensation. So you have to, we get more cows, the 3rd one is for me, the next 2 are for you, the 3rd one for me, the next 2, the 3rd one for me. According to the plaintiff, that was the agreement. And the plaintiff further alleged that these terms of the contracts were based upon a local custom of cattle breeders. If you go among cattle breeders, he was trying to say that this was a settled practice, a settled usage among them. And that the parties specifically incorporated this custom in their oral agreement. And the plaintiff further made the point that the cows produce 46 calves. And according to the custom of cattle breeders and provisions of the agreement, the plaintiff was entitled to 15 cows, but the defendant had given him only 2 cows. So he had been shortchanged of how many cows? 15 cows, and he has only been given 2. So how many? Okay, some of you definitely have to go back to the commas and take it there. So the defendant denied these allegations and asserted that the plaintiff undertook to adjust the cows for no charge, but as an act of friendship. That we are friends, so if I've brought my cow for you to adjust, why should you behave as if the ordinary person I brought and you want to treat me like that? Eventually, the matter traveled out to the Court of Appeal, and the court held, among other things, that the court to enforce a usage as custom once it was proved that it was accepted as a binding rule regulating the conduct of parties to a transaction within a particular trade. So I think that is the most important point, that if evidence can be brought to establish that a certain usage or a certain practice is very much the case as far as a certain industry or certain business is concerned, then when there's a contract in that particular area, even where the contract is absent, where the contract is silent on it, the court can take evidence and read those other things into it. And the Court of Appeal made a point further that usage was a question of fact, and it was for the court to determine as a fact the existence of the custom. Yeah, so just giving us an idea of how you can establish that a custom existed. And the court was saying that the custom was proved not from what the witnesses thought the custom was, but by facts which established what was publicly done in the particular trade in the district where the dispute arose. So if you look at it, the custom being referred to here is very similar to how customary law is also defined in the Constitution. If you remember the definition of customary law as per Article 11, can you be kind to tell us? There, Anita, Enyunam. Transport or safety. Anybody? Emily? Yes. I know you will not disappoint me. Yes.
The common law of Ghana shall comprise the rules generally known as the common law. The rules generally known as the doctrine of equity.
Yeah, so look at the 11 clause. Is it 5 or 7? Clause 3.
For the purpose of this article, customary law means the rules of law, which are custom and applicable to particular communities in Ghana.
Good. So particular communities in Ghana is, somewhat similar to the reason of the court. Because when the court said that, yes, we have to look at the facts and find out what was obviously done in a particular trade in the district where the dispute arose. And the court made the point that if we look at the circumstances of this case, the witnesses who gave evidence of the trade custom must be able to cite instances in which a party has submitted willy-nilly to what was said to be the customary mode of performance or the customary claim, thereby recognizing the binding force of the custom. Simply, the court is trying to say that you don't just say that this is a custom and then the court will accept it and read terms. The court will need to be persuaded that, yes, as a matter of fact, publicly, this is what is known to be the custom. And even you, the parties, your actions, previous conduct should also be understood as having respected that custom as being binding upon you, as it were. All those things are very important in establishing the existence of the custom. I would also like you to look at the case of the Hasnem Enterprise Limited against IBM World Trade Corporation. And the court will still re-emphasize the point you have seen in the Kwate and the Noga case regarding how a custom is established and how a custom may also be relied upon to imply terms. And sometimes, in appropriate cases, it may even be used to control the scope or the operation of the express terms of the contract. Now, let's look at the third way in which terms is implied. Terms implied by the court. The court to imply terms. In other words, in addition to what the parties have expressly included in the contract, the court too may read some terms into the contract. So those are what we mean by terms implied by the court. And how does the court imply terms? So that is what we want to look at. How does the court imply terms? Well, as far as the courts are concerned, they may imply terms in one of two ways. The court may imply terms either in fact or by law. What do we mean by this? Let's take terms implied by courts, in fact. And then we come and take terms implied by courts in law. Now, when the courts are interpreting terms implied in fact, they are seeking to give effect to the unexpressed intention of the parties. In other words, the courts are trying to say that if you look at the express terms which the parties have made, there may be some certain things which are mixing or certain omissions. And if the attention of the parties has been drawn to it, they will have readily agreed that it should be included as part of the terms. So when the courts are trying to do that, the court says that they are not doing anything strange. They are not doing anything different from what the parties themselves have done. And that they are trying to give effect to the unexpressed intention of the parties. So there are two ways in which the court may want to imply terms. So first, a term may be implied by the court because it is necessary to give business efficacy to the contract. And this is expression you shouldn't forget. Business efficacy to the contract. So the court may imply term in order to give a business efficacy to the contract. And what do we mean by that? That is to say that the courts are saying that if these terms are not read into the contract, are not implied into the contract, the contract which the parties have made cannot achieve its purpose. It will be unworkable. And the parties did not intend to have a workable contract. The parties wanted the contract to be workable. They wanted the contract to be implementable. But the courts are saying that if we do not read these terms and just leave the contract as made, it will be impracticable, it will be unworkable. The purpose for which it was made will be defeated. And that certainly was not the thinking of the parties, that we make a contract in which we cannot carry it out. We cannot achieve the purpose. And for that matter, the court will try and fill in the supposed, if you like, a gap to make it, and is doing that in order to give business efficacy, to let the contract be able to serve its purpose. And a very well-known case, and every student, I say every student, so if after, not even after this class, because I asked you to read, if after this time you don't know it, then you are yet to become law students of contracts. The case is the Muko case. The Muko case, very interesting case. And because it's interesting, and some of you have started showing signs that even when you are called, you will not speak. I'll not also call you. So what happened in the Muko case? The defendants were WAF fingers who had agreed that, WAF fingers, just like you have something like a mini pot, if you like jet, you have a jet. Yeah, so that was the arrangement, that they had agreed that in consideration of payments to be made for landing and also stowing cargo, they will allow the plaintiff, a ship owner, to have his ship discharged at their jetty. The jetty is like, if you like, a mini harbor or a mini seaport. The jetty extended into the Thames, River Thames. Those who have been to London, and as both parties realized, the vessel must ground at low tide. That is when the water is low. Then, if the water is low and then the ship comes, the ship will go to the seabed, and that is dangerous. So that is another thing. Good. Now, the ship eventually came, and when it was unloading, the tide ebbed, and she actually settled on a ridge, hard ground beneath it. The water was low, so of course, remember displacement in science. Then it's how to land on the hard ground, and that caused serious damage to the vessel. So the owner of the ship sued the owner of the jetty for the compensation, that you accepted that my ship could stop here, load and unload, and you did not let me know that the tide or the water level was no good, so that if my ship came, there was a high risk that the ship will actually have to get down to the ground, and there may be a rock or something like that, which will cause destruction. The contract was silent on whether the duty of the owner of the facility included alerting a ship owner who wanted to bring his ship, as whether the timing in terms of the level of the water was safe or not safe. The contract was very much silent on that. So when the matter came to court, the defendants, among other things, argued that, well, they had not guaranteed the safety of the anchorage or like the ship, that it would be safe. That was not part of the contract. But the court disagreed, and their lordship, especially Lord Justice Bowen, speaking for the court, had the following to say, and I quote, and if you read what I asked you to read, you have come across it already, so quote, I believe if one were to take all the cases, and there are many, of implied warranties or covenants in law, it will be found that in all of them, the law is raising an implication from the presumed intention of the parties, with the object of giving to the transaction such efficacy as both parties must have intended that at all events it should have. In business transactions such as this, what the law desires to effect by the implication is to give such business efficacy to the transaction as must have been intended at all events by both parties who are businessmen. The question is, what inference is to be drawn where the parties are dealing with each other on the assumption that the negotiations are to have some fruit, and where they say nothing about the burden of this unseen peril, leaving the law to raise such inferences as are reasonable from the very nature of the transaction. Unquote. So Lord Justice Bowen emphatically articulated the principle that so long as we accept that the parties to the contract are businessmen, such as we saw in the Mukwa case, then certainly they must have intended, even if that intention is not evident, if it's not apparent, if they did not expressly say so, that they wanted the contract to achieve its purpose. And for that matter, where the contract is silent, it will not be out of place for the court to read additional terms to fulfill the presumed but unexpressed intention of the parties. So coming back to the facts of the Mukwa case, by the way, before I come back to that, somebody would be wondering, the Mukwa, what is that? Well, the Mukwa is actually the name of a vessel. And henceforth, when it comes to vessels or ship-related cases, we often don't use the name of the parties themselves in the suit. We use the name of the vessel as the title of the case. So like the Mukwa is not the name of a person. It's the name of the vessel. And so that is how it is. Just like those who took discussion of damages last semester serious. You came across Henry 2 and Henry 1. Remember that Heron 2. Some are pretending, but they didn't. Yeah, so coming back to the Mukwa, the facts of the Mukwa case, the court was saying that certainly, as reasonable businessmen, it's beyond dispute that no businessman will bring his ship to your facility and say that, well, I don't expect that you have any responsibility concerning the safety of the vessel that have brought. No businessman will do that. So that was what the court was trying to suggest. And for that matter, the court said that in order to actually give effect to what, in order to give effect to what the parties had agreed upon, it was necessary to read additional terms. So the court read additional terms to give business what? Efficacy. So I hope you all understand how terms will be implied by the courts in order to give business efficacy. And the authority, which we should never forget, in the case of the MUCO. The MUCO, you should never forget whether you are sleeping or you are awake. Yeah, so if you read the case of Ado and Nati, the MUCOC principle was applied. And there are plethora of authorities in which MUCOC has been applied. So, for example, just to let you know that our course readily apply MUCOC. Just having regard to holding two of Ado and Nati, the point was made that the trial judge imported into the contract an implied term that on failure by the defendants to pay the balance on due date, their right to possession into the rent of the premises shall cease. The court continued. It is elementary that no principles are to be implied in a written contract unless such terms can be said to be mutually intended and necessary to give business efficacy to the contract. It seems manifest that such a term would not have been intended by the parties, much less by the defendants. So simply, the court is just telling us that for good reason, and that good reason is to ensure that the parties achieve their business purpose of making that contract. The court may want to imply terms. Another way by which the court may imply terms, in fact, we are still dealing with terms implied by court in fact. We haven't come to terms implied by court in law. We come there. Another way by which the court may imply terms in fact is when the court is making use of the officials bystander test. Officials bystander test. And what do you mean by that? Well, by this approach, what happens is that the court is implying terms, reading terms, on the basis that if a bystander had been present at the time the two parties were negotiating the contract, and if that bystander had drawn attention of the two parties to something which appears to have escaped them, the two parties will have readily agreed and will even shout, yes, of course, it's also part of it. In other words, they will readily accept what the bystander has suggested without even disputing it. And it may well be that it was just inadvertence which had made it escape them. So the court may assume position of the official's bystander and try to read additional terms. If it is in a legislative drafting or interpretation code that to fill the causus omissus, what the parties have actually omitted, then they will try and put there. Because in that case, the court is saying that if at the time the two parties were making the contract, there had been a disinterested bystander, genuinely observing and listening to what the both parties were doing, and realizing that something essential had escaped them, and just pointed out to them, and both parties will have readily agreed and said, yes, of course, it's part of what we are trying to do. So the court can use that to also imply what? Imply terms. as happened in the well-known case of Spring against National Amalgamated Stevedores and Dockers Society. Very interesting case decided in 1956. And I don't know if Adoma Yeboah Michael, Adoma Yeboah Michael, is he a male or female? Because the combination of the names are not without interest. A male or female? Male, yes. Michael, what are you? Michael, yes, prove that you are really here, you're a man. So, what happened in Spring against National Amalgamated Stevedores and Dockers Society? But did you come across it in the week? If I allow you to go and look at your paper, can you see it? You come here and pick your paper. Yes, anybody? Any volunteer? Okay, since you are not volunteer myself. The defendants in Spring case and the Transport and General Workers Union agreed at the Trade Union Congress at the Bradlington in 1939, setting rules for the transfer of members from one union to another. This was called Bradlington Agreements. In 1955, the defendants, in breach of this agreement, admitted the plaintiff to their society. He knew nothing of the agreement, that is, nothing of the Bradlington Agreement, nor was it expressly included in the defendant rules. The breach of the agreement was submitted to the Disputes Committee of the Trade Union Congress, which ordered the defendant to expel the plaintiff from their society. When the defendant sought to do so, the plaintiff sued them for breach of contract, claimed a declaration that the expulsion was ultra-vires and asked for an injunction to prevent that. The defendants, on the other hand, suggested that a term should be implied in their contract with the plaintiff that they should comply with the Bradlington Agreement and take any appropriate steps to fulfill it. So eventually, when the matter came before the courts, the first court or the court of first instance at Lancaster rejected the suggestion and granted the declaration that there had been a breach. And a point was made by Lord Justice Mackinnon, which provides the requisite support for the principle that we are trying to develop. And I quote, if that test was to be applied to the facts of this case, and the bystander had asked the plaintiff at the time when the plaintiff paid his 5 shilling and signed acceptance form, wouldn't you put into it some reference to the Bradlington Agreement? I think, indeed, I have no doubt that the plaintiff will have answered, what is that? In other words, the court was trying to say that we will only imply terms, in fact, going by this official bystander test, if the situation is such that the particular term you are proposing as being a term which should imply in fact, is it such that at the time that the contract, if we decide to play back, can we say that if a third party had been present when both parties were negotiating the contract, and that third party had mention that particular term you are seeking the court to imply into the contract, both parties have readily agreed as at that time that what you said is supposed to form part of the contract. So that is the important test which should be used in trying to imply terms. Well, let's come to the second way by which the courts imply terms. So terms implied in law. So still terms implied by court, but this time terms implied by courts in law. If you look at terms implied by court in fact, using the officials bystander test and then using the business law efficacy test. So now I want to talk about terms implied by the courts in law. And that is pretty straightforward. What happens is that when terms are implied in law, they are implied into all contracts of a particular kind, and that with emphasis. What do you mean by that? With respect to terms implied in fact, the terms implied in fact, whether by business efficacy or by officials bystander test, those terms are implied in the contract between the two parties and does not make a universal rule or universal principle. But with respect to terms implied in law, when terms are implied in law, they are implied not only to a contract between A and B, but they are implied into contracts of the same kind as a contract between A and B that may happen in future. And the court will be doing so usually as a matter of public policy. And a typical example, before we came to have the Labor Act, before we came to have the Labor Act of 2003, for example, we used to have various case law, judicial decisions on various aspects of employee-employer contract, employment contracts, master-servant relationship. And for example, the common law will propound a principle that in a contract between employer and employee, the employer can summarily dismiss the employee if the employee disobeys reasonable instruction by the employer. So let's say that this is a principle which one case has developed. Now, terms have been implied, but it's not going to be restricted to the particular case in which this principle is developed. Should there be other contract of employment, other contracts between employee and employer, the court will say that yes, there's implied duty that the employee should obey reasonable instruction of the employer. Otherwise, the employer reserves the right to summarily dismiss the employee. So that is what we should take note of. Yeah, so that's my listening is going to go in a second. So since we are friends, you can come and put my power on. Some of you to go off. Oh, that's the blue. This one will bring you. Let me pause this. Yeah, so we were talking about terms implied by the court in law. And we made the point that where terms are implied in law, what it simply means is that they are implied into all contracts of a particular kind. And the court is trying to put into effect the party's intention, and at the same time, it's also trying to impose an obligation on one party, maybe such as public policy. You'll be discussing illegality in public policy. And public policy may come in to change or modify how the parties have agreed upon. For example, you enter into a contract, and let's say you say that when you stop working for your employer, you're not going to do any similar work for any other employer for the rest of your life. Public policy will come in and say that such a contract in restraint of trade is unreasonable because the duration by which you are binding yourself not to work for a rival of your former employer is excessive and unnecessarily long and all that. So that is what we should keep in mind. Now, who also came across the case of Liverpool City Council against Aaron, since some of you are football lovers? Liverpool City Council. Very interesting case, as well as the case of the Leicester against Romford High School storage. You didn't come across it? Yes, yes, good. What's your name? Papaya, please, let's hear you. About the league. Oh, right, yes, because my heart, I started getting palpitations because I thought you were talking about the league. So that's why I was worried. Can you speak up so that those on the Zoom can also hear?
I am saying that the defendant has already occupied
Yes, hurry up.
All right. So the defendant some time ago, before the plaintiff came to the scene, acquired a premises under a lease, and the time was up for him to renew it when the plaintiff came into the scene. And it was a premises purposely meant for commercial purposes. So the defendant, the plaintiff was saying the defendant cannot sleep at the premises. He can only use that place for commercial purposes. And the defendant was saying that he wants to renew the lease if he will not be allowed to sleep at the premises.
No, we are talking about Liverpool City Council against Owen. Remember, we are taking us to, remember that case? No, you go ahead.
So the man was saying, the defendant was saying that he will not renew the lease if he will not be allowed to sleep at the premises. So the plaintiff just agreed that okay, fine, you will be allowed to sleep over there.
No. What you have said is a very interesting answer for another case, which is not being discussed now. So maybe let's come back to the case we are discussing now. We are talking about Liverpool City Council against Owen. I mean, the City Council, they own a lot of flats. You go to UK, you have what they call the council flats and all that. So this defendant was living in one of those flats, and yeah, it's off now. Yes.
So connect to the
Sure. Yeah, so in Liverpool against Arwin, the defendants were living in flats owned by the plaintiff, city council flats. And it had stairs and also lifts. But that building was subject matter of regular vandalism, just like how some of you students misbehave in some of the halls of residence, which you shouldn't do, by the way, because if you did that, we will arrest you, and if you arrest you, not only taking you to the police station, we also dismiss you. You don't want to be dismissed, so you have to comport yourself as a serious one, student. So, the stairs rubbish were left by some of the tenants. The staircase, the lift was not working most of the times and all that. So it got to a time, the defendant became fed up and said that not until the city council, as the owner of the property, had put it in order, they protested that we are not going to pay the rent. If you don't fix the broken stairs, the messy, the rubbish and all that, if you don't do that, we're not going to pay the rent. So they sued the defendants in order to get them out for having breached the contract, because you are saying you won't pay the rent. So you are denying the title of your landlord. Now, when the matter came before court, the Liverpool City Council, among other things, argued that there was no implied terms on their part that they will actually keep the broken stairs and lifts and fix all those things. There was no implied terms in the contract imposing that obligation on the council. So that was their argument. But the House of Lords rejected that argument and held that it was necessary to consider what obligations the nature of the contract itself implicitly requires. What obligation the nature of the contract itself implicitly requires. What is the contract? The contract for people to have accommodation in a property owned by you and all that. If the owner of the property did not have obligation to ensure that the property was kept in a very safe and proper order and so on, will it be fit for accommodation? So that was the kind of reason the House of Lords was referring to. But the court was also prepared to say that since it was not possible to live in such a building without access to the stairs and provision of a lift service, it was necessary to imply some term as to these matters. If we read the story, the full judgment, these people were living on the 9th floor of a 15-story. There is a 15-floor tower, and the defendants were living on the 9th floor. The stairs were out of order, and the lifts were out of order. And the stair too was actually not kept in good condition, as they put a lot of rubbish and other things on the stairs, as it were. So the court was saying that defendants living at the 9th floor, certainly they need lifts. Or if they are not going to get the lift, then the stairways or the staircase should be in a proper order. So despite the fact that the contract might have been silent on this obligation on the part of the landlord, the court was of the view that having regard to the nature of the contract, it was necessary to imply or to read in this additional obligation. And the court held further that it was sufficient to imply an obligation on the landlord to take reasonable care to maintain to maintain the common parts in a state of reasonable repair. Yeah, so that was the thinking of the court as it were. So please, I've noted that you are not taking briefing of your cases serious. I'm going to give you this material and then the reading list as well. Before I come to class next week, you must have briefed all the cases. I'll call your name. When I come next week, God willing, I call your name. You not stand at where you are, you come and stand by my side. I'll let you remove your mask. I have taken 2 doses, so if you remove your mask by my side, I'm protected. And then everybody will look at you. And then I will subject you to interrogation regarding the cases. But that is the only way. I have to use the naming and shaming approach so that you will sit up and read. You are too young. I don't know what to do with your time. As an old man like me, I go to bed at 2 a.m. and I don't see what to do with your time. So if you are not learning, then I don't know what you are doing. You have just how many subjects? 4 or 5? What? Even if you have 10, it's nothing. What do you do with your time? Don't waste your time on social media, please. Don't waste your time on social media. If you are using social media, apart from strict purposes of learning, don't waste your time. When you go home on vacation, you can do that. When you are in school as a law student, there are too many things to read. So the time is not enough. If you want to be a serious law student and become a serious lawyer or serious legal person in the future, you have to read. So all the cases that we mentioned, we as lecturers, we can't have the luxury of time to go into the nuances of every single case with you. We only give you the digest and the aspects relevant to the point that we want to teach you. But it's still your responsibility to go and read the full judgment. All right? Now, okay, so we have 15 minutes, and I intend to continue. So remain calm. Now continue for a few minutes. And I also try to record this and put it on YouTube for you so you can play it back as and when you want. That is why I am recording when I am teaching. Okay, so let me do it this way.